Welcome to another episode of Quick Question with top producing Twin Cities realtor Dave Oswald. Now, join Dave as he answers your questions about residential real estate.
When putting together a purchase agreement, one of the forms we have is an addendum to the purchase agreement for arbitration. In a real estate transaction, the buyer and the seller have to agree as to how they'll handle disputes, if there are any in the future. So arbitration is provided, and that is an opportunity for the buyer and the seller to sit down with a hired arbitrator and work through their disagreement. Perhaps it's something that wasn't disclosed, or perhaps it was something that came up after the sale that neither party knew about. And an arbitrator really has to help them work through their differences and decide on a fair and equitable solution to their problem. Now, I'm often asked as we're filling out purchase agreement paperwork, Dave, should we agree to arbitration or should we not agree to arbitration? It's a good question. I'm not a lawyer. I can't answer legal questions for you. As a matter of fact, I'm barred from doing so. But let me give you my opinion. Arbitration, if you're a buyer, if you have a problem with a home that you've purchased after the closing and you want to resolve a dispute, arbitration's a great way to go. It's very civilized. You don't go to a courtroom, you hire an arbitrator, and the fee right now is around $550. $550 hires an arbitrator to sit down and listen to your issues in a conference room, and it's very comfortable and not too intimidating. That seller, when we put that agreement in front of them, the entire purchase agreement, gets to decide whether or not they agree to arbitration as a means of dispute resolution or not. So even if you agree to it and the seller doesn't agree to it, it's kind of all bets are off. So from a buyer's perspective, the advantage is there's no financial limit. If you've got a big problem with the house that you just bought, there's no financial limitations on what you can bring to an arbitrator for a resolution. There is a time limit. You have to do it within 24 months. So you say, well, what's the alternative to that? Well, here's the alternative. You can go to conciliation court. It used to be called small claims court. And the filing fee, at least the filing fee in Dakota County, is $75. Technically, the filing fee is $65 plus a $10 contribution to the law library, but that adds up to $75. And you can go before a judge and plead your case. Now, the disadvantage for you as a buyer is that there's a $15,000 limit. There's no time limit. You don't have to do it in 24 or 36 or 48 months. You can do it anytime you want. But it's only $75 to go to conciliation court. So you make that decision early on in the process, and it's up to you to do it. I can't give you legal advice. From a seller's perspective, should you agree to arbitration if the buyer has agreed to arbitration? My own personal opinion is, yeah, why not? They have a high barrier to entry, $550 versus $75 in conciliation court. $550 barrier to entry into the arbitration process. So they're not going to try to arbitrate something small and frivolous. So those are my ideas about whether to agree or decline arbitration. I hope that answers the question for you too. I'm Dave Oswald. We'll see you next time with another quick question.
Have a quick question about residential real estate? Email it to us at quickquestion@daveoswaldhomes.com.